This is Chicago's very own WGN Evening News at 6.
Illinois will soon be the first state in the nation to fully eliminate cash bail. The state Supreme Court ruled today the controversial change is constitutional 6 months after being first slated to take effect.
Yeah, 5-2 majority also rejected claims that lawmakers overstepped their authority. The decision is a victory for Governor Pritzker and other advocates who say the current system unfairly impacts poor Black and brown residents.
The odds tend to bend in favor of justice, and I think today is a historic moment for Illinois.
I remain concerned that we're going to see spikes in certain areas of crime and certain people because we can't hold them.
New cashless bail system will begin statewide September 18th. That's also when some detainees who could not pay their original bail can petition the court for release. And much has been made about the many state's attorneys who opposed the original draft of the bill, but the version upheld today had many amendments. And joining me to talk more about the state Supreme Court's decision is Chicago-Kent law professor Harold Krent. Professor, thanks for being with us once again. First off, give me your reaction to what the court said today. Is it what you expected?
It was a 5-2 decision, and I think the Illinois Supreme Court sensibly relied upon its separation of powers precedents to uphold the General Assembly's decision to end cash bail. The court very carefully looked at the language of the Constitution, deciding that the General Assembly had the discretion to adjust the pre-release system that Illinois employed. And of course, there is a mechanism in the Safety T Act to make sure that those individuals who commit violent crimes and who may commit violent crimes in the future will not be released, even though cash bail is ending in Illinois.
Were you expecting the justices to uphold the law?
I was, though obviously it was never always, there's some doubt until the decision comes out. And in this case, the court held that the General Assembly and the judiciary jointly have both interest and involvement in setting the pre-release system in Illinois. And I think the court sensibly struck a line saying that the end of cash bail is within the General Assembly's discretion, and it's still in terms of the determination of whether someone will be too dangerous to let out should be left in the judge's hands at a special hearing that will take place.
So it really did get into the branch of government's individual powers here, but the decision really split very sharply along political lines. What do you say that says about the political nature of all of this?
Well, it did, and you're absolutely right. And this is a politicized issue. There's no question. And obviously, many of the state's attorneys and sheriffs who contested the act were Republican. So it's probably not surprising that the court fractured along the lines that it did. Though I don't really see this as a particularly politicized issue, despite the trappings. I think this is actually a very important separation of powers decision, saying that the lower court got it wrong by saying that this act trenched upon the judiciary's power. The General Assembly makes decisions in terms of sentencing, makes decisions in terms of criminal procedure, that rules are to be followed in a trial, and similarly, it can decide what to do about the end of cash bail. Whether this is a great move or not is by the General Assembly is unclear. Other jurisdictions that have ended cash bail have not seen any kind of uptick in violence. So let's hope that happens here, and let's hope that the last set of revisions that were urged by many states' attorneys and were accepted by the General Assembly, that could make a big difference. And I think we'll see what happens starting in the middle of September.
Well, you talked a little bit about this perceived potential uptick in violence. The plaintiffs argued that getting rid of cash bail would definitely result in an uptick in violence here. What exactly did the court say about that aspect of this?
Well, there is a mechanism in the Safety Act which is designed to ensure that any suspect who is deemed to be in danger of committing another violent act should not be released on bail. And it's up to the state's attorneys to make the case that individuals, because of their violence, because they have a grudge against somebody, because of their severe mental illness, would create some kind of danger if they had been released. So those hearings will be held. And if the court deems that an individual may be prone to violence or may be prone to vengeance, they should stay in jail. And the jurisdictions in New Jersey and New York that have adopted a cashless bail system have not seen any kind of increase in violence. So there's every good reason to think that that will be the same here in Illinois.
The nation will be watching Illinois. Professor Harold Krent from the Kent College of Law, thanks for being with us once again.
Take care.